Judge, at this time, consistent with our pretrial motion, we move for judgment of acquittal on both counts. I'm trying to decide which to begin with. We know that the culpable negligence standard, even though it might sound like negligence, is actually by law considered the more difficult offense to prove for the state. And you'll see there's an anomaly that culpable negligence is also considered a lesser included offense of recklessness. So we're going to have a lot of complications if we get to the jury instruction phase. But for the moment, if we start with the vessel homicide, which uses the word reckless, the state has to prove more than that there was a crash, because that's res ipsa loquitur maybe for ordinary negligence, but the fact of the elision doesn't prove that this was a crime. And the fact that the object wasn't moving, in this case a marker, likewise doesn't prove it's a crime. And in the 14 or so cases that we had cited pre-trial, and we have more, and overnight, we dig every day. You encouraged us, and we've gone outside of Florida. We're going to submit to you additional points of authority. In cases where a woman walking across the street with a baby stroller gets run over, of course, it would be easy enough for the state to say that constitutes recklessness, and yet on all of those cases that we cited to you, the Court of Appeals said it wasn't enough. And those were cases that the trial judge let it go to the jury convicted, appeal, reversed in 14 cases. So let's look at what are the facts that the state has proven here. We know the elephant in the courtroom is the state's effort to try to suggest that George Pino was impaired, but there's just no evidence of it. The evidence that they have 2 beers over the course of several hours, in 2.5 hours, or close to 3, and no evidence that the consumption of that quantity of beer led to any kind of impairment. Every witness who has testified on that question has negated the suggestion of impairment. And we don't need to call out the witnesses, Judge, because they were all in unison on that. But I'm sure I'm going to hear about that from the state. They're going to say, well, maybe it was more than 2 beers. There's no evidence of it. And what we have is no evidence of impairment. So if we can remove impairment, remove the effort to turn this into a BUI case when it's not, what we're left with is the elision itself. The speed is not itself proof of anything. This is not a speeding case because there's no speed limit in the channel. Not then, not now. And the conditions were excellent for boating. I think you heard testimony from law enforcement officers who confirmed that. At least one.
Let me ask you a question. Sorry to interrupt.
Please.
Speed, you say, there's no speed limit. Okay. So, is there a point where speed is reasonable or not reasonable under the totality of the circumstances of operation?
There could be in certain cases, although we know from Lizardo where the guy was driving 80 some odd miles an hour towards the Miccosukee Trail and was in fact violating the speed limit. The court said that wasn't enough. Here we have.
Well, what else was there in Lizardo?
It was speed, and he crashed right into the other car.
Besides speed in the crash, were there any other evidence of any other conduct?
I don't believe in Lizardo. I think that was the gravamen of it. And still, the judge let it go to the jury.
I understand that.
Well, let me say, Lizardo was the conditional plea. The court rejected the motion to dismiss.
I understand.
Right. And so Lizardo makes clear that even way over speed limit is not enough. And right. And here we don't even have a violation of a speed limit.
Because there is none.
Exactly.
That's my question. What? Would there ever be speed on the water that could be considered unreasonable?
There could be. If, for example, the vessel that was being used can't handle the speed, for example. That's one example. This boat, the Robalo, there's no doubt that this boat is built to handle that level of speed. So In that case, there's no suggestion that speed in and of itself put anybody's life in jeopardy. If the elision had not occurred, speed would have put nobody at risk. The speed itself did not create. There was no other boat in the channel. There's no risk of elision. I mean, there's no risk of collision. There was an elision. And so the speed itself did not jeopardize the lives of anybody on that boat. Now, we have the evidence of the law enforcement officers who themselves were operating at that speed. I think one officer said he was traveling between 40 and 45 miles an hour with passengers, the less injured passengers on the bow, seated on the floor of the boat, and thought it was perfectly safe. So you have that evidence to consider in terms of whether George Pino drove in a way that's any more dangerous than the way law enforcement says was not dangerous. This suggestion that having 7 passengers on the front seating, the way the boat is designed, again, no evidence that put them at risk under the conditions that we have. So by way of example, you didn't hear anything about choppy seas, precipitation. Conditions were ideal. So this boat was built for this speed with this number of passengers. So we take alcohol impairment not proven, speed not excessive, not unreasonable for the conditions that happened here. Whether there had been 7 passengers in the bow or just 1 passenger in the bow, the elision it's the elision that caused the injuries and the death. It wasn't the number of passengers or the speed. Had the speed been 30 miles an hour and you go into a fixed object, someone could be seriously hurt if not killed. So the speed isn't the issue. The issue, I think, what the state's best case is that the operator, George Pino, didn't see the marker. Because I think everybody agrees had he seen it, he would not have never intended to hit it, and he would have avoided if he had seen it. And so the question is,
I don't have any evidence in front of me that, no evidence that Mr. Pino, I don't believe, because I think the state's charges would have been different. Mr. Pino, viewing and seeing the marker, drove that boat into the marker.
that was their point in opening statement, that it would have been a murder charge, right? That's their point.
Okay.
So we assume that their theory is he did not see it, because if he had, they'd be charging a much different crime. And so if you assume that he just didn't see it, for whatever reason he was distracted, that doesn't prove culpable negligence, doesn't prove recklessness. That's negligence at best. You didn't see the stop sign. You ran the stop sign. Your defense, why did you run the stop sign? Because I didn't see it, Your Honor. And I ran the stop sign. 99 times out of 100, nobody gets killed when there's a stop sign run. But on the one time that someone is running the stop sign, that's plain view, the driver says he didn't see it, does not result in homicide charges. I didn't see the light. I missed it. Yes, I've been through that intersection 100 times. The light turned red. I was distracted. I went through the intersection. Someone gets killed. That is not culpable negligence. That's not recklessness. It has to be a course of conduct so wanton, so willful, so consciously indifferent to the outcome. There has to be some depravity in the mind of the operator, not just a lapse in missing the stop sign or not yielding in going into an intersection, entering I-95 and not yielding to a car that's coming and an accident happens. Because, of course, once contact is made with another object, someone's going to get hurt. But that doesn't turn it into a crime. And whatever your view is about recklessness, Judge, as to culpable negligence, if McCreary, the state of Florida Supreme Court, means something, we're not quite sure what it means, it has to be even, I guess, more depravity of heart in the way that the operator was operating the vessel. So we're struggling to understand what the difference between those two standards are. So as far as manslaughter goes, the more, call it, serious charge, I don't know how the state's going to distinguish between recklessness and culpable negligence, but whatever those tests are, the state's easier argument's got to be recklessness, And yet, we still don't have anything that the state has offered to explain other than the elision itself. They're defining recklessness as the fact that the elision occurred. But that proves too much. That's just res ipsa loquitur. That's just ordinary negligence. Thank you, Judge.
Thank you so much. All right, state, prima facie evidence, your standard, your burden.
The standard, Your Honor, is that no rational trier of fact could find that the state of Florida met the elements of these two offenses beyond and to the exclusion of every reasonable doubt. Moreover, at this stage in the trial, the court has to give every inference in favor to the state. The state submits, we have submitted competent and substantial evidence that a rational trier of fact could in fact use to find the state has met the elements. Number one, as to vessel homicide, that George Pino operated his vessel in a reckless manner likely to cause the death of or great bodily harm to another person, and two, that his reckless operation of the vessel caused or contributed to the cause of death of Lucy Fernandez. I don't need to instruct the court, obviously, on what the definition of recklessness is. But
Willful and wanton disregard.
Yes.
Right, for the safety of persons.
Intentional, knowing, or purposeful is willful.
Okay.
So to the extent that Your Honor now has not just the evidence from the state's traverse for the sworn motion to dismiss that was filed pre-trial, but now the court has heard actual evidence to show that this defendant changed course of direction that placed him on a complete collision course with channel marker 15. That is an intentional, knowing, and purposeful act. Not that he is intentionally and purposefully going to try to run into the channel marker, but that he's the one at the helm dictating what the speed of that vessel will be and what the heading of that vessel will be. To the extent that wanton means conscious and intentional difference to consequences, and with the knowledge that damage is likely to be done to persons or property, we have that as well, Your Honor. The evidence is clear and unrebutted that this defendant, by his own words, by the words from his GPS device, and from the words of other witnesses, this man knows that body of water very well. He's been through that channel a multiple number of times. On top of that, Judge, he's gone past specifically channel marker 15 numerous times. So if you know where that channel marker is, and you nevertheless decide to pursue a course in your vessel that puts you on a collision course with it, and which I know Your Honor was not in a position to see all the video footage, which of course is available to the court. But when Mr. Albert was on the stand, I would stop, pause those videos to show that way before even where that final track mark is, channel marker 15 is clearly visible. The sun wasn't in the defendant's eyes as he's heading toward the east, and the sun would be setting in the west. There's no evidence that there's anything to obstruct his view. What there is evidence of is that this defendant either was driving blindfolded, looking somewhere else other than where he was supposed to go, because he had 9 seconds plus to say, oh my goodness, I need to change course.
So is that the level of wantonness and willfulness that defines the actions as reckless?
Yes, because
versus ordinary negligence.
This is way more, Judge. This isn't, oops, I ran a stop sign. This is, I see a stop sign in the road in front of me and I'm going to run right into it. This isn't a momentary lapse of reason. This is a course of conduct that anyone, especially someone with his level of boating experience, would know. If you run into in a stationary steel pole that is in the bay for the purpose of keeping you safe, that has a day glow green marker, and you just run into it when it's right in front of you in broad daylight, how is that possible? Other than, as I said in my opening statement, you're checked out, you're zoned out. I don't know what was going on. The defense has done an admirable job defending the defendant against a charge of boating under the influence manslaughter. But I've never charged him with that offense. I've never said that he was impaired. He's the one that put into issue that he had been drinking alcohol, and that was corroborated by his wife and by two other witnesses, Mr. Fernandez as well as Carolina Monterey. So the fact that he had alcohol in his system is clearly an issue that goes along with the knowledge of this location.
Well, do you think that that establishes a failure to use ordinary care? In other words, I asked the state, what evidence have you presented to establish that Mr. Pino exhibited a failure to use, beyond a failure to use ordinary care?
If the court thinks that the only thing
That's
ordinary...
negligence. That's the...
If the court believes that running for 9 seconds right into a channel marker that's clearly and highly visible in broad daylight at this...
What were the efforts to avoid? Was that the last one there from the GPS data?
There was no effort to avoid until like a second before impact, when I guess he finally snaps to it and it's like, oh my goodness. And that's why we have that one last track mark. But at the rate of speed that he was traveling with the weight of all those passengers on that vessel is not agile to the point where it can not hit that channel marker. He put into play a series of events that led to him striking that channel marker. And it's not res ipsa loquitur. The fact that he ran into it in and of itself, of course, is not proof that he was reckless. But we don't have just res ipsa loquitur. We have GPS. We have testimony about his knowledge of that location. We have testimony about the weight added to his vessel.
Well, there have to be certain willful decisions, right?
And how about a willful decision not to course correct when you see that you have a deadly channel marker ahead of you if you don't course correct? Inaction in this situation was the action.
That's what I was getting. Could that be, in terms of evidence, the evidence of failure to act, cause the conduct or lack of conduct to rise to the level of something done ordinarily?
Absolutely. And Judge, I would strongly urge the court, because of, unfortunately, the makeup and the design of this courtroom, it's impossible for the court to see.
No, I can see it.
On the screen? Oh, from the mirror, Your Honor could see it? Okay. I take that back, sorry. That being said, then, I would think that the court can all the more appreciate that if a person has every reason in the world to see a hazard up ahead and has all the means available to avoid that, and that person doesn't take any action, then that person is choosing a course of conduct that is going to likely result in death or serious bodily injury. And that is wanton. So have I established with competent substantial evidence that the defendant was reckless because he was willful and wanton? Yes, but the crime of vessel homicide requires the state only to prove that he was willful or wanton. I submit the evidence shows both. And as to the charge of manslaughter, the state charged the defendant with manslaughter under 2 theories. Yes, one of those theories is culpable negligence, which, yes, we know from case law is considered a higher burden of proof than even recklessness.
Well, isn't that interesting, because isn't that the lesser for the vessel homicide?
The opposite. Vessel homicide.
Vessel homicide being the lesser of the manslaughter.
It can be, yes, depending on how the charges are pled. In this particular case, the state chose to charge the defendant with each of those offenses separately. And it's my intention to argue to the jurors that, yes, this evidence is competent, substantial to prove beyond a reasonable doubt that the defendant acted recklessly. However, I am willing and prepared to go the extra step and say, but not only was it reckless, it also rises to the level of, and this is where I get to the point of the way that the state charged the defendant with manslaughter. I charged him with manslaughter by causing the death of Lucy Fernandez through his own culpable negligence, but I also charged him with manslaughter by intentionally committing an act or acts that caused the death of Miss Fernandez. And here, The act or acts was his decision to continue to plow forward as fast as that vessel could go, given the weight that was on that vessel, headlong into a channel marker that he knew was there, with a boat full of 17-year-olds, many of whom had been engaged in consumption of alcohol, so that if, heaven forbid, there's an emergency, their ability to react to it is going to be less, which, in addition, that none of them are wearing life jackets.
You know, you come back to that.
In part because it seemed that the court understood that recklessness is not just the way that you drive your boat, it's all of the factors taken into account.
Well, again, not just the way you drive a boat, but when you talk about all of the factors, it's not a type of contributory negligence because the girls were drinking or not drinking. You would say, see, I don't know how the ability of the girls to respond or not respond go to the criminality, if it is, of Mr. Pino.
Because if Mr. Pino is on notice that the passengers on his vessel are going to be less able to react in an emergency, but he nevertheless places them in a position where they are going to be facing an emergency, then his decision to consciously disregard their vulnerability goes to him being A, reckless, and B, culpably negligent.
So not taking steps beforehand to prepare all of the circumstances, given all the circumstances, to prepare for a worst case scenario. To anticipate.
When you have precious cargo, when you have vulnerable cargo, if a person is driving with, 100 cartons of eggs, they're going to be a little more careful than if they're driving around with 20 cans of, vegetables. You've got to be aware of who your passengers are. And he was acutely aware of who they were, first of all, because he's known many of them for years. Second of all, because he and his wife were supplying many of them with alcohol. And third, because we can see the girls are obviously having a good time, and they've already talked about the fact that they were consuming. I'm not charging him with, providing alcohol to minors. But the fact that that did happen does go to the vulnerability of his passengers, and it means that he has a duty to keep them safe. And could he have maybe done that better by driving slower, by maybe operating his vessel on the proper side of the channel? All of those things are things that go to his culpable negligence. And the concept that...
So he becomes culpably negligent in your argument. And it's gross and flagrant, because it has to be gross and flagrant and apparent, by, for example, not supplying life vests to all girls, by not driving slower. Is that what you...
What I would say, Your Honor, is this. If there was no one on that vessel besides the defendant and his wife, and if his wife was in a life jacket, but he was traveling at this rate of speed, following this course that we know down the Cutter Bank Channel, and slammed into that channel marker, if God forbid his wife had died, he would be guilty of reckless homicide. He would be guilty of vessel homicide, because his decision to operate his vessel in that way, where it was likely that death or great bodily harm would result, was reckless. But what makes this cross that threshold from reckless into culpable negligence is the fact that the boat wasn't just with one other person. And the other people on that vessel were not wearing life jackets. The people on that vessel were minors. The people on that vessel, many of them, had been consuming alcohol. The defendant himself admits that he had been consuming alcohol. And so that's what makes this, for lack of a better term, reckless plus. And that is why the state charged him not just with vessel homicide, but also with manslaughter. Also factoring in, forget about the navigational rules for a charge of vessel homicide. But we know what they are. The jury's heard evidence of it. The court obviously can take judicial notice of what the navigational rules are. And then when we compound that recklessness with the fact that he is obviously not keeping lookout, when we compound it with the fact that he's operating at a speed that's not safe, that he did not do anything to avoid A, the risk of a collision, or B, to avoid the collision itself, that's what places this case in the category of reckless plus. And that's why the state submits, Judge, that viewing the light most favorable to the state, this court has to deny the motion for a judgment of acquittal.
Yeah, it sort of sounds like she's saying that he actually did intend to run into the piling. Because now she's saying that he turned, went straight ahead, and he took no action as if he intended to do it. But I thought when we started this conversation, we understood that that's not what the state's theory at least was until today. Till today, the theory was he didn't see the piling. If he had, he'd be charged with murder. But it sounds to me like she's now saying, well, maybe he did commit murder.
I'm not sure I interpreted the argument.
Well, what is she saying? That because he'd been there before, he should have known it was there and he should have taken action to avoid it? Okay, as if he knows it's there and he's still driving in a way that is going to put everybody in harm's way with some mens rea. Up till now, I thought their theory was that he just didn't see it. Had he seen it, he obviously would not have kept going to hit it. And when he got, apparently the boat took evasive action within a second or so of striking the piling when it became clear that there was going to be a collision, an elision. So it sounds to me that they're sort of mixing the two concepts. I think that there's no evidence that, as she said, he was blindfolded. And the case law is just super clear. Let's just go to the cases, and these are the instructions that I understand you'll be giving the jury from the Esposito case. Neither carelessness nor ordinary negligence in the operation of a vessel are sufficient to sustain a conviction for vessel homicide. Simple negligence cannot by itself give rise to criminal liability. Quote, the degree of culpability required for a vehicular homicide, vessel homicide, is more than a mere failure to use ordinary care. Speed alone does not constitute reckless conduct unless the speed is shown to be grossly excessive. The presence of central nervous system depressants like alcohol in the bloodstream after the crash in and of itself is insufficient to support a finding of reckless operation of a vessel. So you see these cases continue to make clear it's just not enough even to have alcohol in your system is not enough. And here there's no evidence of impairment. The state must prove beyond a reasonable doubt that the act was not the result of momentary lapse of memory, inattention, or mistake of judgment. A finding of simple inattentiveness is woefully insufficient to state a prima facie case of reckless driving, open paren, willful, and wanton driving behavior. That's State versus Esposito, a direct quote. And so you have a standard here that requires some intentional act, but not simply he intended to drive the vessel. We all understand he was intending to operate the vessel. The question is, was he intending to put his passengers in harm's way and intentionally aiming at the marker, which I thought we understood would constitute a depraved heart and could support murder if his intention was to hit the marker. And then the idea that if there's a carton of eggs on board, that somehow changes the duty of care. I think that's the analogy that the state was using. The fact that some of the passengers may be of a younger age or some are intoxicated. Of course, if he hits the piling, whether you're intoxicated or not, whether you're old or young, that could cause serious injury, bodily harm, and death. So again, I think they continue to define the crime by the elision itself. And under their theory, catastrophic injury coupled with an elision equals reckless per se. That's what they're telling you. Ask the state to define a scenario where that wouldn't be the case. Elision plus catastrophic injury That's what they're relying upon, to say that when that happens, it's a crime. But that's not what the case law says, Judge. Thank you.
Very good. Thank you. Okay. I will give you my decision on the motions in the morning. See you all in the morning at 9:30. And that's, I think, all we have to say.
Thank you.